All right, I'd like to reintroduce the panel. I'm Sid Mendelson. Immediately on my right is Stan Judd. On his right, Sid Simmet. And on his immediate right, Larry Bardfeld. Now, continuing where we left off in our previous session, with respect to cash items, I'd like to give you an example of when a CD, this is a very simplistic example, when a CD may be considered a cash item. Suppose you had a company making suits, men's suits, and he goes through a cyclical year in which a part of the year he accumulates inventory and a part of the year he sells the manufactured suits, and then the process starts all over again. Now, during the course, during the period, during the cycle in which he is selling the suits and not buying material, he takes that money and he puts it into CDs, for example. These CDs will be cashed when the need to accumulate inventory comes up, say, in the fall or the spring, whatever his cycle is. And therefore, he's only putting that money into something besides a can in the backyard, so to speak, in order to get some type of return on that money. But that is only incidental to his business of manufacturing suits. On the other hand, now suppose, for example, the suit business isn't working out so well for several years, and there's no need to accumulate inventory because he didn't sell out his inventory, and so he has a lot of material left over. So he takes those CDs that were, say, 6-month CDs, and he turns them over. And when the time comes for those CDs to mature, he turns them over again, because he doesn't need he doesn't need to accumulate inventory. At that point, those CDs may well turn into what we would term investment securities, because he may no longer be in the business of manufacturing suits, but in some other business, and that business might well be investing in CDs. Now, that's a very simplistic example, but it does illustrate how something that would ordinarily be considered a cash item by people outside of the investment company can turn into investment securities by what the purpose is in the investing process. And in one case, the investing purpose was merely to put the money aside until you need it at a time certain. And the other purpose, in the latter part of the example, was the putting the money in the CDs became the purpose in itself. Okay, sir.
Thank you. I'm going to just conclude our treatment of Section 3A1 and Section 3A3, the definition of investment company. There's a third definition, as I said earlier, which will be described later. I want to complete this by talking about 4 particular situations that involve the statutory definition of investment company. The first is the matter of the Prudential Insurance Company of America, a very large insurance company which was issuing variable annuity contracts. Let me go back a step. Prior to litigation involving Prudential, there had been litigation which went all the way up to the Supreme Court involving the Variable Annuity Life Insurance Company of America, which is generally referred to as VALIC, and it was held that the variable annuity contracts, it was held by the Supreme Court that variable annuity contracts were securities rather than conventional contracts of insurance, and so VALIC was, since it was predominantly engaged in issuing these contracts, was not entitled to the statutory exclusion, which we'll discuss later in Section 3C3 of the Investment Company Act for insurance companies. Prudential, on the other hand, was a huge insurance company. VALIC, you see, did almost nothing else but issue variable annuity contracts. Prudential was predominantly not in the business of issuing variable annuity contracts, but rather did very little of that, and did it through a little account, which they called a separate account. It was just a count on the books of Prudential that was created by the sale of the variable annuity contracts. This gave rise, the Circuit Court held, and the Commission urged, to a separate investment company within the meaning of the Act. So, as noted before, an issuer, which you need to find an investment company, can be a company, but that company does not have to be a recognized legal entity. The Court of Appeals agreed and said that the resulting fund, and not Prudential, was the issuer of the contracts for purposes of the Investment Company Act. You don't need a recognizable business entity. The Court thought that the Congress had intentionally drafted the definition of investment company in general terms to control situations just like this, where investors commit funds to others with a view to investment in securities, and their fortunes depend upon the success of the investment, and that's true regardless of the legal form in which the investment enterprise is put. This is the so-called ectoplasmic theory, that is, the fund, the separate account on the books of the equitable, is separable from the insurance company, even though as a matter of state law the assets of the fund are just another asset of the insurance company. A few other cases. SEC versus First National City Bank, 1970. The Commission sought to enjoin the bank's Special Investment Advisory Service, SIAS, and Merrill Lynch from offering and selling any security issued by SIAS and from operating SIAS. It was alleged that this was an unincorporated fund primarily engaged in the investment company business, and that the security issued by SIAS included a power of attorney executed by the investor authorizing the bank at its discretion to trade for investors for the investor's account through Merrill Lynch. And the question put to the people who went into SIAS was whether they had an objective of growth or income. There was a $25,000 minimum investment, and there was some promise of individualized attention, but SIS funds were in fact invested in two groups of securities, one group for growth-oriented investors and one for income-oriented investors, and once a decision was made to buy or sell for either part of the SIAS service, First National City Bank applied this decision across the board. The complaint was dismissed by the district court, but that was all part of a well-orchestrated affair under which the defendant stopped the SIAS service and offered some substitute non-discretionary service. The significance is found here, too, for our purposes now, is that SIAS was the issuer of security and primarily engaged in the business of investing in securities. Another brief example. I said before, a natural person can be an issuer of a security. That is, you need an issuer. An issuer is a person, and a person is defined in the Act to be a natural person or a company. Take the case of someone who wrote to us and said, I'm going to, please send me your money. I promise to pay you 8%. I'll take the money and invest it in securities with the hope of earning more than the 8% I've promised you. That could be a natural person, which is an investment company. Finally, let me just touch upon the issue of tender offers. Now, if you think about it for a moment, you'll realize that when an acquiring company goes after a target company, if the acquiring company is not successful in getting 50% or more of the voting securities of the target company. Then the target company's stock held by the acquiring company could be investment securities as to the acquiring company, and it's therefore possible that at some point in the acquisition program, the acquiring company could become a Section 3A3 investment company, depending on the numbers. That is, if the acquisition being made is of a small company by a very large company, that may not occur. But let's consider the case of, very generally, of the Slick Corporation, S-L-I-C-K, which goes back to the year 1969. It made an exchange offer to holders of Filtrol Corporation, and it was determined that Slick would be a 3A3 company when it got 30% of Filtrol's stock, though it intended to get more than 50% of Filtrol's stock. But at the point it got 30%, then it would have, with all of its other investment securities, more than 40% of its assets in investment securities. Anyway, to get to the end of that, what was worked out was this. The company made an agreement with the commission that when it got 30% of the when it got 30% of the Filtrol stock, which would make it a 3A3 investment company, it would file a 3B2 application, which Stan Judd will describe in a moment, but that gives you a 60-day grace period. That is, you're free from the act for 60 days, if it's filed in good faith. If at the end of that 60-day period they still didn't have 50% or more of the stock, the voting securities of Filtrol, and they didn't have an order of the commission saying they were primarily engaged in some non-investment company business, then they agreed to sell Filtrol stock so that what they held of it and all other investment securities would not exceed 35% of the value of their assets on an unconsolidated basis. And in fact, they took a further step and agreed that if they somehow didn't do that fast enough, the commission could get an injunction and a receiver could be appointed to make sure they got down to those percentages. That concludes what I have to say this morning about 3A1 and 3A3, and Stan Judd now will discuss with you Section 3B, which follows naturally from the definitional sections in 3A.
Before Stan starts, I'd like to make a statement because these tapes may be subject to an FOIA request. I'd like to state for the record that any statements made here are made without necessarily having the agreement of the commission or without necessarily being the policy of the division. These statements being made up here are being made extemporaneously and in some cases without the necessary research that would form a policy of the division. So consequently, I believe that the statements made here should be considered merely the opinions of those making them at the time they were made. Thank you.
I'm glad you said that. Sid has sort of indicated the alternative structure of the definition of an investment company in 3A of the Act, and has indicated how in Section 3A1 of the Act, a company is an investment company if it's engaged in the business, primarily engaged in the business of investing, reinvesting, and trading in securities. And under 3A3 of the Act, there is added to those kinds of activities which can make a company an investment company, the words owning or holding. And as indicated under 3A3 of the Act, a company can be an investment company if it's engaged in the business of investing, reinvesting, trading, owning, or holding securities, and has more than 40% of its assets invested in investment securities. Now, if you look at that, you can see that how under 3A3 of the Act, there would possibly be covered a company which is engaged as a holding company in holding securities of companies that it engages in their businesses, where those holdings constitute less than 50% of the securities of the held company. In other words, if they held only majority-owned subsidiaries, so long as they were not engaged in the business of investment companies, would be accepted from the definition of an investment security, and these companies wouldn't have any problem under 3A3 of the Act. But should they own less than 50% of the securities of the held company, then those securities would be considered investment securities, even though they were engaged in the business of the company that they held. But it was not the intention of the framers of the Act that a holding company that was really engaged in the business of operating its held companies, that company should be regulated as an investment company. So in order to deal with that situation, to create an exception for the true holding company, let's say, from the definition of an investment company, whereas they had under 3A3 sort of cast a net that might embrace such a company, they added Section 3B to the Act. I think it's very important to notice that the introductory clause to Section 3B is notwithstanding the provisions of subparagraph 3 of paragraph A above. In other words, the provisions of Section 3B really apply only to Section 3A3 investment companies. They do not apply to a company which would be an investment company under 3A1 of the Act, or a company that would be an investment company under 3A2 of the Act. It's only a company that would be an investment company under 3A3 of the Act that the provisions of Section 3B apply. Later on I'll make a little amendment to that in terms of what our policy is, but in terms of what the statute says, that seems to be clear. That's the provisions of 3B apply to Section 3A3 investment companies. Now when you get to 3B, it's broken up into 3 subparagraphs, 3B1, 2, and 3. And if you look at, first let's just look at the differences between 3B1 and 3B2. 3B1 basically provides an automatic exception to the definition of an investment company contained in 3A3 for any company which is primarily engaged either directly or through wholly owned subsidiaries in a business or businesses other than that of an investment company.
Now that's wholly owned subsidiaries. That's a key word here, wholly owned.
And it's in that aspect that is one of the differences between 3B1 and 3B2, that this only applies to companies which could be said to be primarily engaged directly or through wholly owned subsidiaries in a business or business other than that of investing in securities. And this exception, as I said, applies automatically. Doesn't require any commission order, doesn't require any rule, any regulation. Someone comes within these provisions is not included as an investment company. Now, I think that the test of primary and what has been said as to what one looks at to determine whether someone is primarily engaged in one business or another apply here for purposes of applying 3B1 and also for purposes of applying 3B2. That is the asset composition the source of income, where the income comes from, the historical representations of what the company's business is, their present representations, and the activities of officers and directors. And of all those factors, the first two, assets and income, are really the most important. And it's only if after you can't really get a clear picture of what the company's primary business is from looking at those two factors that the other factors would have significance.
The annual reports here are very significant. For example, are they pointing? Is the company pointing with pride to its business, to its investment business, or is it looking rather to its manufacturing business? At the annual meetings, do the officers get up and talk about how good their investment business was for the preceding year? Or are they talking in terms of how their manufacturing or service business was? All of these things are taken into consideration in looking over a 3B1, or for that matter, later in a 3B2 situation.
Let me give you a hypothetical situation. A company has 40% of its assets in investment securities. As a result, it's a 3A3 company, and one must look to provisions of 3B to determine as to whether or not it's an investment company or not. Now, when you look further at the company, you find that 30% of its assets are directly engaged in business A, and 30% of its assets are engaged in a business B, which it conducts directly. Now, applying the provisions of the Act, 3A, provisions of 3B1, what is the primary engagement of this company with respect to whether or not it's engaged primarily in the investment company business or in some other businesses? Well, I think it's clear that what the Act does is create a balance of investment company activities on one side and all other activities, and we're talking about 3B1, conducted directly or through wholly owned subsidiaries on another. So that with respect to this particular problem, while you might say, well, they have a greater percentage of their assets in investment securities than in any other business, that's their primary business. But that's not the question as far as 3B1 is concerned. The question is, do they have more in an investment company business than they have in all other businesses combined, which they operate directly or through wholly owned subsidiaries? And if you look at that, you would see they had 60% in directly engaged businesses, 40% in investment securities, and therefore they're primarily engaged in a business or businesses other than that of an investment company.
Let me complicate the matter for you a little bit, Stan. Suppose the same ratio applies, but the companies are losing money in their non-business activities and making money in their investment activities. How would the staff view it at that point, in your view?
Well, in my view, basically, I would say that it's very difficult for me to see a situation occurring in which a company would be said to be primarily engaged in an investment company business if it had a greater proportion of its assets invested in some other business. Now, there are cases, however, where you might find a situation where a company, let's say, has proportion of its assets in the situation that you mentioned, and where you find, let's say, that it has a greater amount of its income, of its net income, coming from the business of investing in securities. Now, that may happen because what you may find, for example, is that a company has an operating business. It has a gross income, for example, of over, let's say, $1,100,000 from the operating business, but it has costs of operation, which, let's say, directed towards that operating business of the same thing. So if you looked at its gross, looked at the net income coming from the operating business, you would say doesn't have any net income coming from the operating business. Now you look at the investment side of the business, and they have, let's say, $150,000 coming from that. Now their expenses in running, let's say, a portfolio of securities is really very, very little. So let's say they have $125,000 of net income coming from their investment business. Now, if you looked at the whole picture, you'd say, well, they have $1,200,000 in total gross income, $1,100,000 of which came from the operating business. If you looked at gross income, you'd say, my God, their business is primarily that of the operating business. If you looked at the net income side, however, you would say the only net income they had came from their securities business. The Commission has never really said what factor you look to when they talk about looking to income, whether you look to gross income or whether you look to net income. I think really you have to look to both of these factors. I would suspect that in some of these cases where we find that a company is running an operating business but it's losing money, and it has a portfolio of securities which are smaller in assets than their operating business, but they're making money on that, you will find that they're usually using the income coming from the investment security portfolio to support their losses in their other business. Now, I submit that when you find a company that's using its income coming from securities to support its losses in its operating business, that's an indication that the primary business is not the security business, but it is the operating business.
Well, I agree with what you said, but I think I could pose a situation to you of the inadvertent investment company where the business of the inadvertent of the company is declining. Say you're in a construction company where you have a lot of heavy equipment, which and the construction business is declining for some reason or other. And the efforts of the company are being used, the cash of the company is being used not necessarily to support the construction business, which is becoming somewhat of a minor operation, even though the assets in this heavy construction equipment are still on the company's books. But that the company is now in a different business, is now directing its efforts towards securities, and one could even see a sale of a piece of equipment when that could be made in order to use that money for investment purposes rather than, as in your example, to support the construction business. Can you see a situation of that sort, Stan?
A situation could exist, and of course, in every one of these situations, one has to look at the particular facts involving the case before you. And there isn't really too much that can be said that can provide real guidance to decide the particular case. Because the particular case, when you have a case, it's usually a close case. And one has to really look at the whole situation and come to some kind of a responsible and reasonable assessment of what the primary engagement of the company is.
In American Hawaiian steamship lines, I think that some of these characteristics were true. American Hawaiian was going out of the business of steamships, of shipping, and was going into the business of investing, and they still had some liners that they hadn't yet sold, and there were some of these characteristics involved. I think some of the characteristics that we have here were involved in Fifth Avenue, where some of the buses were still in. Some of the buses in the subsidiaries were still owned by the company, and they were attempting to say they were still in the transportation business, and the staff and the commission in the case approved otherwise to the court. But I think what Stan is trying to say here, we can set up general standards, but each case has to be looked at in its own, through its own characteristics. In other words, the way I like to do this is that if I could be looked down from above and say, I'm the ultimate investor, I'm going to invest in this company. What am I going to invest in it for? Am I going to invest in it because it's a shipping company or it's a business, or am I going to invest in it because I'm looking toward an indirect source of investments? Now that's a generalization and an oversimplification. But I think in applying these various tests that Stan is talking about, and in enforcement actions, you try to go above this thing and look down and say, if you were an investor that had all the facts, and you were thinking of investing or not investing in this company, what would be the points that you'd be looking at in order to determine whether you should or should not go into this company? And I think to an extent, when we get these applications in, or when we look at a 3B1 company, we try to put ourselves into that position and take all of these facts. Now, Stan is, I think, very ably shown you 99% of the time what would be a determination, but not 100%. So there's no sure thing when you're in the status area.
Well, as a result of that, Sid, what happens, what we see happening, is a company, let's say, is in 3A3, and there's a question of whether or not it's out under 3B1. Now, counsel looks at the matter, and he thinks that the company is primarily engaged in a business other than that of investing in securities through, let's say, wholly owned subsidiaries. Nevertheless, he sees that there is a question concerning the matter. And as Sidney says, it's very difficult when you get a sort of a close case to be absolutely certain of what the situation is. Well, in that situation, it's not unusual for counsel to make or for the company to make an application under Section 3B2 of the Act for an order of the Commission finding that it is primarily engaged in a business or businesses other than that of an investment company. And that is one of the major differences between Section 3B2 and 3B1. That is, Section 3B2 is a process in which the Commission may order a company accepted from the definition under 3A3, or make a finding that a company is primarily engaged through directly or through majority-owned subsidiaries. Notice the difference from 3B1. Or through controlled companies engaged in similar business or businesses.
Now the big point here is this. The filing of an application, the successful filing of an application and the granting of an order gives that company, at least for that period of time in which the Commission has made its findings, an insurance policy. If the Commission says it's not an investment company, it's very much like a declaratory order. The company can rely on it. It's a defense against suits from shareholders, for example, or from anyone else who's claiming that a contract is illegal because the company was an investment company and thereby operating in violation of law. And we'll get into that this afternoon. However, if the company relies on 3B1, it takes the chance of litigating with the Commission in a different forum. That is, in a court where the Commission will be looking forward toward an injunction, and all of the disadvantages that a judgment against the company will bring. Conceivably, it could even be a criminal case. So when you go into when the council decides to go into a 3B2 situation, He's looking at rather vis-a-vis taking advantage of 3B1, where he says, as far as I'm concerned, you're not an investment company. Here's my opinion, and that's it. In doubtful cases, and in cases sometimes not so doubtful, he would rather have an insurance policy issued by the commission, a finding that the company is in fact not an investment company. In one case, it's litigated at the commission as an administrative matter, not an enforcement matter. And in the other case, it's litigated in a court as enforcement litigation. So there is a difference, and that's why counsel, in many instances, would prefer to look toward an order rather than to rely on 3B1.
You know that, as Sidney has indicated, we would permit a company that was, let's say, primarily engaged through either directly or through wholly owned subsidiaries to file an application under 3B2. In other words, we read the phrase majority-owned subsidiaries under 3B2 as, of course, including any company which was more than majority-owned, wholly owned, or whatever it might be. There's an interesting question, I think, which has come up under 3B2, and Sidney Simmons has kind of alluded to the situation which gives rise to the problem, and that is the takeover struggle that goes on of one company trying to take over another company and the target company seeking any defense that it can find against the takeover. One of the defenses which may be available to the company is that the takeover company is an unregistered investment company, in which case the transactions and everything involved would be void, as we'll get into later. So
now, a recent case of that, which is prominently in the newspapers, is National Airlines and the attempt to be taken over by Texas International. Texas International, through its control person, Jet Capital, filed a 3B2 application trying to get an order from the commission that it was not an investment company, even though it owned shares of Texas International, and Texas International in turn owned shares of National Airlines. And the question, and lo and behold, when the staff noticed when the commission noticed that application, who should come in to intervene but National Airlines, saying that this whole thing is illegal because there's an investment company involved and it's unregistered, and therefore it asked for a hearing. Certain developments may come about which will make this application entirely moot. But National intervening here did it because National did not want to be taken over, apparently, by Texas International, and would rather have been taken over by someone else at possibly better terms. So the defense of these things and the intervention does not always come in with the purity of somebody coming in the national interest to say here is a company that's operating in violation of law. It uses its intervention as a weapon to frustrate its being taken over.
Well, now, a question which may arise is, can the target company, if it believes that the takeover company is an unregistered investment company, what can it do about it? What can it do under the Investment Company Act? Could the company, for example, file an application under 3B2 to have the takeover company declared to be an unregistered investment company? Well, if you look at the language of 3B2 specifically, it says an issuer may apply for an order of the Commission as to its status under the Act, for an order of the Commission declaring that it is engaged directly or through majority-owned subsidiaries or controlled companies engaged in a similar business, in a business other than that of an investment company. So if you just looked at the language of the Act, I think that you would come to the conclusion that there is no authority in Section 3B2 for someone other than the person about whom the determination is to be made to come before the Commission and ask for such order. And then you might ask yourself, what would be the significance of such an order by the Commission if it should make it? What weight would it have in court? And so on. There's lots of issues about that type of thing.
Well, usually, minus a 3B2 application, the strategy of the target company is to come in what it calls its public purpose and its interest in the public good, screaming and hollering that the takeover person is an investment company. They use they will go to the Division of Enforcement or to our division in order to interest us in this problem, so that we will in fact bother the company, if you will, and either force it to register, tell it it is an investment company, it isn't registered, and conceivably all of the acquisition of securities that it has previously made is in violation of the Investment Company Act and therefore voidable. All of these, so that they use us in many instances to help them pull their chestnuts, if you will, out of the fire. And it's not always as they suggest in the public good or in the public interest. It's in self-interest.
CNA Corporation in 1974, when faced with a takeover attempt, which was ultimately rather successful by Lowe's Corporation, asked the Commission to enter an order in its discretion determining that Lowe's was an unregistered investment company. And the Commission in that case, without deciding whether it had discretion to make such a determination, declined to exercise such discretion.
Yes, sir.
In the National Airlines situation, you indicated that National had made an attempt to intervene in the proceedings which were instituted by the company instituting the takeover. Are there any provisions for intervention, and what are the mechanics of that intervention? Is there a hearing to determine whether it's an investment company, and if there is a hearing, would National then participate and present evidence or documentation?
There are provisions of the Commission's general rules which deal with questions concerning intervention, as to who may intervene and what kinds of participation he may be permitted. For example, if the person would be directly affected, he may be permitted to be as a party. He may be permitted to cross-examine witnesses. He may be permitted to introduce witnesses. He may be permitted to argue before the Commission. It's all up to the hearing judge as to what rights he will permit the intervener to have.
So that even though even though National could not initially commence the proceeding, once it were instituted, then National could be treated as a party or as a party by virtue of the fact that they were so substantially affected, and would have in essence the same rights as any party.
It would be up to the hearing judge as to what rights to give to the person. And one of the things that you have on applications is, under the Act, that an application, before it can result in an order, has to be noticed publicly. And when there is public notice, that gives the people the opportunity to request a hearing if the staff itself has not set down a matter for a hearing. For example, someone may file an application. Let's say the staff thinks, well, it's fairly clear that the company is entitled to the order which it's requested, so they don't request a hearing. The matter goes out with a notice. It says that this company has applied for an order saying that it's not an investment company, and anybody who's interested has an opportunity to request a hearing on the matter. Now, let's say somebody comes in with respect to that and requests a hearing. not in all cases where people request hearings does the commission order a hearing. To some extent, the staff reviews the merits of the issues raised by the person requesting a hearing to determine whether it would be in the public interest to have a hearing. Now, if there is a hearing, then the person goes before the hearing judge and says, please permit us to enter into the proceeding to participate because of our great interest in the matter.
Now, it is whether he has an interest, which the commission will recognize as reasons for intervention. But if Section 40 of the Investment Company Act says, orders of the commission under this title shall be issued only after appropriate notice and opportunity for hearing. Now, somebody may not have an interest. In other words, if you get some pressure group, for example, that just decides that they want to go in and have a hearing, even though they have no interest in the specific application. For example, they may, for some reason or other, they may think that this company is dealing with South Africa or something of that sort, and they want to go in and intervene and say that when the commission finds in a case in the public interest that any company dealing with South Africa can't be in the public interest. So in many instances, well, I shouldn't say many, but in several instances, the staff has taken the position that the intervener has no interest, and it is so briefed the commission and or the hearing officer, at which point a decision is made as to whether this intervener has in fact an interest in the application before the commission.
Turning back to the substance of 3B2, there is one phrase that I'd like to say something more on, and that is the concept of engaged in business through controlled companies engaged in a similar business. And that language has somehow raised some questions as to the meaning of similar business. Similar business to whom? There was some thought at one time by some of the people who write about these matters that it referred to a similar business to that of the parent company. So that if you were concerned about what the parent company's primary engagement was, and you set up the sort of a balance that I suggested with the investment security non-operative, let's say, activities on one side, and the operative activities which could be included under the non-investment company business on the other side, and a company had a controlled company that it was operating, that controlled company, in order to be added to the non-investment side of the balance, would have to be in the same business as the parent. But in the American Manufacturing Company case, the Commission indicated that the phrase referred to similar business to that of another controlled company, which seems to mean that, for example, if you had a company with four controlled companies, the first engaged in business A1, the second in business A2, the third in business B1, and the fourth in B2, that you would be able to include among its non-investment businesses either A1 and A2 or B1 and B2, but not all four or even three, and not an A and a B. Is there any questions about that? I think it's also probably true that the first suggestion that some made about the interpretation of similar business may also be true. That is, it may also be interpreted to include a company which is engaged in a similar business to that of the parent company, which the parent company is engaged in directly. in which case then I think it's possible that you might be able to put on the non-investment side businesses that the parent company was engaged in directly, a business of a controlled company which was the same as that business engaged in directly, and perhaps the business of any other controlled companies which were engaged in a similar business among themselves. Now, the question of what is a controlled company? Section 2A9 of the Act defines control as including ownership of more than 25% of the voting stock of a company. That's presumed control. And ownership that's more than 25% is presumed control. And ownership of 25% or less is presumed not to be control. And in both cases, these presumptions may be rebutted. And there's a general definition of control provided by the Act that control is the power to exercise a controlling influence over management or policies of a company unless such power is solely the result of an official position with such company. And one of the questions I would like to raise with you is the question of whether control is a sufficient basis for an exemption under Section 3B2. Is it enough that a company, through its stock ownership, let's say, has the power to exercise a controlling influence if, for example, it doesn't exercise that influence? Now, I think not. I think that the Act requires that the company be engaged in the business of the controlled company, that it exercise its control. That's, I think, very important to the determination. One other type of question that's come up sometimes is, many times a company loans money to another company and it receives various rights to, let's say, veto a business that the company might want to go into, to have some control on the kinds of loans the company might make. And the company may argue that it really is in control of this company to which it's loaned the money, and therefore its investment in this company should be added to its operating side of that balance I spoke about, and not to the investment security or investment company side of the balance. But I think that it's been our position that interest and rights of a secured creditor will not satisfy what's required. That what is involved is not a matter of preserving an interest, that is the interest of the creditor, but of directing a business. In this connection, in terms of what is control, you look sometimes to the activities of the boards of directors and officers of the parent company. Do they sit on the boards of the companies they allegedly control? Do they constitute a majority? Do they review the important business transactions of the controlled company, and so on?
Who appoints the officers of the so-called controlled company? All of this is real control.
Now, and one other element that's important here is when you look at this situation, when you look at a 3B1 situation, or you look at a 3B2 situation, and you're trying to determine what the primary engagement of the company is and what percentage of its assets does it have in one business and what percentage does it have in another, do you look at this on a consolidated basis or do you look at it on an unconsolidated basis? Well, 3A3, the thing that throws you into 3B1 to begin with, refers to looking at the matter on an unconsolidated basis. But it's been our position that that doesn't necessarily control the way you look at the matter from the point of view of determining whether a company is primarily engaged in investment company business or primarily engaged in other businesses. Basically, we would say that you have to look at whatever test gives you a better picture, a truer picture of what the real engagement, if you can use that word, the real engagement of the company is. Now, it's been mentioned that there is a temporary exemption of 60 days. The Commission has the power to extend these temporary exemptions. Usually the extensions are done under Section 6C and 6E of the Investment Company Act. perhaps for the reason that under those sections the Commission is specifically authorized to impose various conditions, either on the applicant or on people who relate to the applicant. We will take a break for a few minutes, and then we will resume with 3B3.